Good morning, and welcome to part one of our Legal Expense Fund Regulation Overview training. I'm Maura Leary, an Associate Counsel at OGE, and I have with me my colleague Heather Jones, who is our Senior Counsel for Financial Disclosure. The purpose of this training is to provide a big picture overview of and context for the new Legal Expense Fund regulation. We also will flag some important items for you to remember if you have an employee ask you about setting up a legal expense fund. Part two of this training will provide details about how to accept pro bono services under the new regulation. We will have an additional training on the nuts and bolts of how to establish a legal expense fund in late October of 2023, as well as a live question and answer session on November 8th, which is shortly before the regulation goes into effect on November 21st, 2023. We also plan additional technical trainings later in the year and into next year. Slide 2, please. You may have seen that OGE published the Legal Expense Fund Regulation 5 CFR 2635 Subpart J on May 25th, 2023. Why did we take this action? So I'm going to back up a little bit and talk about the big picture. As you have likely seen just from watching the news, there are times when executive branch employees may face legal action arising from their government employment and thus will need to pay for legal expenses. Some examples include times when government employees need to testify before Congress, when they're involved in an IG investigation, or if they're facing personnel or employment actions. Those are just a few examples. Legal counsel for actions like these can be very costly, and one method to defray those costs is to establish a legal expense fund. That's a fund where other people may donate money to help cover someone else's legal expenses. Slide 3, please. There have been established rules for setting such legal expense funds in the legislative branch for many years, but there was no such framework for executive branch employees. So what if an executive branch employee was facing legal expenses stemming from their government job and wanted to establish a legal expense fund to help defray those costs? What would happen is that OGE would informally consult to help ensure that the employee complied with the gift rules and other ethics rules, but OGE did not formally approve or disapprove legal expense funds. And reviewing these funds, OGE relied on the analysis that the gift of legal expenses was not given because of official position, but just because of the employee facing this legal matter. Now, this position is counterintuitive because the legal matter wouldn't have come up if it wasn't for the job that the employee had. And this led to a lot of confusion. And there were other problems with this approach too. Specifically, there was no limit to the amount any one person could donate. There was no public disclosure of donors, as there was in the legislative branch. There was no requirement for a fiduciary duty to the beneficiary. And there was no requirement for OGE approval or oversight. In short, there were real appearance and transparency issues with the way things were. Slide 4, please. So, in response to those concerns, in 2018, OGE's director committed to beginning the process of drafting a legal expense fund regulation in order to address some of those issues. Now, this process involved a lot of stakeholder input. OGE held a public hearing. We had a meeting with interested ethics officials. We had a stakeholder meeting with ethics officials, nonprofits, and law firm representatives, and we received a record number of public comments. In fact, it was over 7,000 comments. And the final rule was published in May of this year. Slide 5, please. The new Subpart J creates a clear framework for employees to establish legal expense funds, which must comply with the rules and restrictions laid out in the regulation, and to accept pro bono services under certain circumstances. We'll discuss how both legal expense funds and pro bono services operate under the regulation in more detail a little later on, but just a reminder again that this regulation goes into effect on November 21st, 2023, which is just in time for Thanksgiving. Slide 6, please. In addition, the regulation makes a few related updates to Subpart B. For one, the regulation creates a new Subpart B exception for benefits offered to an employee from an established employee organization. This exception is not limited to legal services, but it allows employees to accept gifts of legal services directly offered by unions or other employee associations. In addition, the regulation adds an explicit gift exception for legal expense funds and pro bono under Subpart J to Subpart B, so it's clear that this is a gift exception that OGE has contemplated. So before we discuss how the legal expense fund rules work under the new regulation, I want to briefly clarify what legal matters are eligible. These rules can only be used for legal matters that arise in connection with an employee's official position, which can be their current position or past position, including a past position on a campaign or transition team, in other words, from their job. It cannot be primarily personal, estate planning or family law, for example. So, for example, if the IRS was investigating both the employee's misuse of government resources and their misreporting of personal taxes, a legal expense fund could be established for the first matter, but not the second. Now I'll turn it over to my colleague, Heather Jones, to talk about the basics of how a legal expense fund trust works.
Hello. This training will provide an overview, high-level overview regarding legal expense fund trust. We'll discuss establishing a legal expense fund trust in more detail in the second nuts and bolts training that will come out in the end of October and go over how ethics officials can review those trusts for approval. Subpart J lays out the basic requirements for establishing a legal expense fund trust, which includes that it has to be a trust, not some other type of legal entity, which provides protections to the beneficiary because the trustee will have a fiduciary duty to the beneficiary. The trust must be for the benefit of a single employee. You cannot have multiple beneficiaries from the same trust because it's harder to screen the donations for conflicts in those cases. Each employee may also only have one trust at a time, even if they have multiple legal matters going. The trust can cover multiple legal matters, but each employee gets one legal expense fund trust. The DAO will review most trusts for approval, and OGE will do a secondary review for certain high-level positions, basically those for which OGE reviews public financial disclosure reports and White House employees. OGE serves as the first reviewer for the reports of DAOs and the reports of anonymous whistleblowers, which will be covered later, and the trust documents and all of the reports that go along with the trust will be publicly posted on the OGE website, and that's for every employee in the executive branch, not just those reviewed by OGE. Next slide, please. There are limitations on who can serve as a trustee for these trusts, and we'll go into those more in the nuts and bolts training. However, they fall into basic categories: people who can't serve as trustees for any legal expense trust, and those who can't serve as a trustee for this particular beneficiary. The key is that the trustee is a fiduciary for the beneficiary. That means they have exclusive control of the assets of the trust, and the employee is not involved in the management of the trust at all. Next slide, please. The regulation also establishes limitations on who can donate and how much they can donate. Generally, individuals are permissible donors. We also allow certain 501c3 organizations to make donations. Those 501c3s must be established at least 2 years prior to the time that the legal matter starts. and then presidential campaigns, vice presidential campaigns, and the national political parties may make donations. There is a $10,000 limit per donation donation total for a calendar year, which is same as the limit for the Senate. The House's limit is $5,000. We chose the higher limit because comments were generally in favor of having a higher limit, but in favor of keeping them close in line with the legislative branch limits. In addition, trusts will be required to, the employees will be required to do quarterly reports reporting the contributions and distributions of $250 or more to the trust. That limit of reporting is the same as the House. Next slide, please. This is a list of prohibited donors, and we're going to talk more about how to figure out if someone falls into those categories in the nuts and bolts training at the end of October. However, again, it's generally two categories. Those types of people who cannot donate to anyone, and those types of people who need to be considered for the individual employees. The concept is different from our prohibited source concept in the gift rules. We received feedback from agencies that the prohibited source concept would foreclose a number of people at agencies from receiving donations from basically anyone, particularly the Commerce Department and the Justice Department. Instead, we created the idea of that kind of a bad prohibited source or a more specific prohibited source that focuses on the employee's duties rather than the duties of the agency. Next slide, please. We received many public comments that asked for 501c3s to be able to donate to legal expense funds, as they are allowed to do so, but only in certain circumstances. The 501c3 must be registered with the IRS as a 501c3 organization. It must be established for 2 years before the beginning of the legal matter, and it must not be substantially affected by the performance of the employee's official duties. So, for example, if the employee was doing grant review for an agency, the employee could not take a donation from a 501c3 that had applied for a grant that they were reviewing. Next slide, please. There are also restrictions on what the employee beneficiary may do after they've established the legal expense fund. And these generally involve the ways that they can solicit for contributions and the types of matters that they need to recuse from. They must recuse from any party matter involving a donor or the trustee for 2 years after the trustee stops serving as the trustee and the whole time while the trustee is serving as trustee, or for 2 years after a donor makes a donation. So if a donor makes a donation of more than $250, and the limit only applies to donors over $250, then they cannot, if they make that donation in January of 2024, then the person would not be able to work on a party matter involving that donor until January of 2026. And if the trustee were, say, also a litigant and representing someone in a case that an attorney at the DOJ was prosecuting, then that prosecutor could not participate in the case where the trustee is representing someone. In addition, we encourage employees to be cognizant not to violate the misuse of position provisions in Subpart G. In particular, don't use your agency seal or agency letterhead in your solicitation materials on your website soliciting donations, because the agency needs not to appear like they're soliciting on your behalf or on behalf of the LEF. Next slide, please. The employee will be required to fill out quarterly reports. OGE has created a new form to do this. It's the OGE Form 601, and it will be available on our webpage on both the forms page and the resource pages for legal expense fund trusts. Don't worry, you don't need it now. The first legal expense fund trust reports won't be due until January 30th. We're going to discuss the details of how to fill out and review these forms in an upcoming nuts and bolts training at the end of the year. But the key point is that employees will be reporting any contribution or distribution that is of more than $250, including those that total more than $250 during the year. And then all these quarterly reports will be posted on the OGE website, not just those of the ones reviewed by OGE. In addition, when an employee is leaving the government or terminating the trust, they will also have to file one final Form 601 detailing all the information before the trust is closed or before they leave the government. These are generally filed with your agency, just like your financial disclosure report, but certain reports will need second-level approval by OGE. Basically, the report review follows the very same approval rules as the trust approval. Next slide, please. We mentioned briefly terminating the trust. Employees can do so basically in two ways. They can voluntarily end their trust at any time. Most will do this when the purpose of the trust is fulfilled, but they may have other reasons to end early. They can end it at any time they choose. However, OGE will require the employee to terminate the LEF trust within 90 days of the conclusion of the legal matter that is the purpose of the trust, or 90 days of the last expense being paid by the trust. We know legal expenses drag out sometime longer than the legal matter, so they are allowed to pick whichever of those dates is later. Next slide, please. OGE has built-in protections in the event the employee beneficiary does not comply with the requirements of Subpart J. If the beneficiary receives an impermissible contribution, which could happen by accident, the trustee must return that contribution to the donor as soon as possible, but in no case later than the next reporting date. So if they receive a contribution in February, they will need to make sure that contribution is returned by the end of April. Also, OGE has the authority to stop the trust from accepting contributions or making distributions if there is continuing or significant noncompliance with the regulation or termination of the trust altogether, depending on the severity of noncompliance. Also, if employee beneficiaries don't file their trust reports on time, they're not allowed to accept donations or make distributions from the trust until they get that quarterly report filed. Now I'm going to turn the presentation back over to Maura to talk about certain special cases. Thank you.
Thank you, Heather. And next slide, slide 15. While what we've covered so far will apply to the vast majority of employees, there are certain categories of employees for whom this process that we've just outlined is a bit different. If an employee is an anonymous whistleblower and they wish to create a legal expense fund, then they have the option to file either with their DAO or directly with OGE to avoid even being associated with a specific agency. In addition, their LEF documents that Heather just discussed, their trust and their quarterly report forms, will not be posted publicly. In addition, DAOs will file their LEFs directly with OGE, since all other employees file with their DAO. And finally, the LEF documents for covert employees will remain at their intelligence agencies, and all documents will be handled in accordance with existing procedures for classified documents. So, for example, if OGE needs to review the LEF of a covert employee, we will work through the established processes for classified documents. So, for example, the OGE employee will travel to a secure agency site. Next slide, please. OGE has a number of resources available on the topic of legal expense funds. We've issued a legal advisory, LA 2305, which provides an overview similar to this training. And we will also have a number of additional resources on our website. There is a handbook for LEF trustees. You'll find a guide to legal expense funds for employees, the OGE Form 601, which is the form that will be used for the quarterly reports that we discussed, as well as model trust provisions for employees to use when setting up an LEF trust. Hopefully you will find those resources helpful. And as we've mentioned earlier, we will be holding several nuts and bolts training sessions focusing on how to set up, administer, and terminate legal expense fund trusts. Thank you very much, and we will rejoin you for the second half of this training shortly.